Let us now look at the Court of Justice of the European Union. The Court of Justice of the European Union is the judicial institution of the European Union. It ensures that in the interpretation and application of the EU treaties, the law is observed. The Court of Justice of the European Union should be seen next to the political institutions of the European Union, institutions from which the Court of Justice of the European Union should be strictly distinguished. The political institutions are the European Council and the Council of the European Union, as well as the European Parliament. The Council of the European Union and the European Parliament form the legislature of the Union. The European Commission is the executive of the European Union. As a judicial institution of the European Union, the Court of Justice of the European Union interprets, applies and enforces EU rules in a uniform manner. Uniform means in the same way for all 27 member states. The Court of Justice also controls the validity of all the EU rules, which means verifies whether these EU rules comply with the treaties on which the European Union is founded, as well as with the Charter of Fundamental Rights of the European Union. The EU treaties and the Charter of Fundamental Rights form the constitutional framework within which EU rules are to be adopted. The Court of Justice in this way enforces the rule of law within the European Union. The rule of EU law means that everyone must obey EU law. Obey the law, including public authorities. Public authorities of the Union itself and of the member states must obey EU law. This is important for EU citizens. Yes, EU citizens draw rights from EU rules. Those rights are being enforced by the Court of Justice of the European Union. The Court of Justice is composed of 27 judges, one per member state. When these judges sit as the Grand Chamber of the Court, they sit with 15 judges out of 27. The Grand Chamber is responsible for dealing with cases which have systemic significance for the functioning of the European Union as a legal order common to 27 member states. The Grand Chamber deals with structural issues which are relevant in all the fields of Union law. When it comes to mainstream interpretation of legislative acts of the Union, the Court sits in chambers of 5 or even, for the easiest cases, 3 judges. The courtroom of the court, the main courtroom, is the center of the activities of pleading and oral argument before the Grand Chamber of the Court, and sometimes also for 5-judge chamber hearings. The parties to the case are represented by their lawyers, and the lawyers argue the case from the perspective of the respective parties. All of this leads to a collegiate deliberation. The Court of Justice of the European Union always speaks through a single judgment in a case. All judges, having sit in the case, deliberate together and come to a single judgment. no dissenting opinions are being allowed. That is why the deliberation process is crucially important. It takes place in this very room. The judges explain the case to one another, explain their standpoints, develop legal arguments, and the president of the bench deciding the case will draw the deliberations to a close in order to come to a single judgment, a single solution of the case. The court operates in a nationality-blind way, which means that a judge can never be asked to sit because of her or his nationality, nor the reverse. A judge can never be recused from sitting because of her or his nationality. All the judges of the Court of Justice are truly European judges. They decide the cases irrespective of the national interests being at stake in the cases pending before the court. As truly European judges, all the members of the court are integrating the national legal traditions and the national cultures tout court in a single decision-making process, in a single judgment. The court is helped, assisted if you like, by 11 advocates general. Advocates general are members of the court but are not judges. They give an opinion which serves as the start for the collegiate deliberation process. The judges will start from the opinion but are not bound by it. And it does occur, especially in difficult cases, that a judgment of the Court of Justice deviates, sometimes rather importantly, from the opinion presented by the Advocate General. The court operates in 24 languages, and this is absolutely key to understand the role of the Court of Justice of the European Union. EU law integrates into the law of the member states. EU law becomes part of the national legal systems of all 27 member states. That is why the rules of EU law exist in 24 official languages of the Union, corresponding to the national languages of the member states. The Court of Justice says the law of the European Union in these same 24 languages, so that all interpretations of Union law made by the Court of Justice will automatically be integrated in the national legal systems of the member states. The Court also draws on the national legal systems when saying the law of the European Union. There is extensive comparative legal research in the national laws of the member states in order to feed in the deliberative process of the Court of Justice, a deliberative process which leads to an interpretation of EU law common to all 27 member states. You can, on the website of the court, easily access all the case law and other activities of the Court of Justice in the language of your choice. All 24 languages are available. Having a whole armada of lawyer linguists and lawyers tout court assisting the judges and the advocates general in their judicial tasks, the court works with 2,500 people. It's a huge institution which is mainly housed in these 3 buildings. Crucially important is to distinguish the Court of Justice of the European Union from the European Court of Human Rights, which is based in the Council of Europe in Strasbourg. The Court of Justice of the European Union is responsible for the law common to the 27 member states of the European Union. It is based in Luxembourg. It deals with all EU rules, whether it be the EU treaties, the EU Charter of Fundamental Rights, the regulations and directives forming the legislative and executive acts of the European Union as a common governance structure for these 27 member states, a common legal order, and this in all EU policy areas which the member states have entrusted on the European Union to be exercised and taken care of in common. This happens, as I already said, in 24 official languages of the Union. The European Court of Human Rights is a totally different instance, fully outside the European Union. It combines 46 states in Europe, including the 27 member states of the European Union, which have committed themselves to respect an international convention called the European Convention on Human Rights, providing for a minimum level of protection of the most basic political and civil rights. It operates in two languages, French and English. That court is a court limited to human rights, and it provides a minimum protection of those rights. The states parties to that convention can protect human rights better under their national constitution or as a member state of the European Union in accordance with the Charter of Fundamental Rights of the European Union, which is part of the European Union constitutional framework and which in many respects protects fundamental rights or human rights in a much more exigent level of protection that is much more intensely. How do cases now come before the Court of Justice of the European Union? EU institutions and member states enjoy direct access to the Court of Justice. Citizens, however, do not normally directly bring their case before the Court of Justice. They will bring their cases to the national court, although the case depends as to its outcome on EU law, and the national court will bring the EU law issues to the Court of Justice. This overview shows how it works. When an EU rule is unclear, a national court will have doubts as to the correct interpretation of EU law, and with correct interpretation, I mean an interpretation which would be held valid in all 27 member states. A national court may say, well, you can interpret it this way or that way, but how can I be sure that all national courts in all the 27 member states will interpret this EU rule in the same way? Therefore, in order to have a definitive, binding interpretation for the European Union as a whole, the national court will ask a preliminary question on the interpretation of the EU rule at stake in the case. The interpretation given by the Court of Justice will be binding in all 27 member states alike. So the aim of this procedure is to achieve a uniform interpretation and subsequently application and enforcement of union law rules. When a member state breaches its obligations flowing from union law, the Commission or another member state can bring an action for failure to fulfill obligations, better known as an infringement action. When the court rules on such an action and finds that an infringement took place, the member state is obliged to implement the judgment of the Court of Justice, meaning that it should do away with the infringement. If it doesn't, in a subsequent phase of the proceedings, the Court of Justice may impose a financial penalty on the member state concerned until it will comply with the judgment. And finally, it is possible that the validity of an EU rule is being contested. In that case, EU institutions or member states may bring an annulment action against that rule before the Court of Justice. If the rule is annulled, it will be considered never to have been part of the EU legal order. But it's also possible that a citizen, when bringing a case to the national court, finds that an EU rule which might determine the outcome of such litigation, that this EU rule is invalid because conflicting with the EU treaties or with the Charter of Fundamental Rights of the European Union. In that case, the national court will ask a preliminary question, this time on the validity of the EU rule at stake in the national court proceedings. If the EU rule is declared invalid, it will no longer be binding in the national court. This scheme shows how the procedure for preliminary rulings works. At the start, it's an EU citizen empowered, claiming his or her rights, finding EU rules from which the citizen claims to draw rights. The citizen will bring this case in the national court. The national court will see the rule and may have doubts as to the correct meaning or even the validity of the rule, because the opposing party may contest the validity of the EU rule. So the national court will ask questions, normally on the interpretation of the EU rule, possibly on the validity of the EU rule. The Court of Justice will give the interpretation, the definitive interpretation, or rule on the validity of the rule. That judgment will be binding not only on the national court, but also on all national judges in all 27 member states. It will be the law of the land. The case of Gabrielle de Frenne illustrates this very well. Gabrielle de Frenne, 50 years ago, was an air hostess, and she claimed against a major airline equal pay for equal work. A rule contained in an article of the EU treaty itself. But the airline, as a defendant in the proceedings, said that the air hostess could not invoke such a rule of EU law in the national legal system. In other words, the defendant airline claimed that the EU rule did not enjoy any direct effect in the domestic legal order of Belgium in this case. The stewardess brought the case before the Belgian court to claim additional pay. The national court doubted about the invocability of this rule of EU law in the Belgian national legal system and asked to the Court of Justice whether that rule was invocable or not as a matter of national law. The court answered that the rule could be invoked directly and should be part of the national legal system, enforced as such by the national court. That's how the case went out in favor of the stewardess who received the back pay. It all shows that the role of the Court of Justice is to make sure that a rule be interpreted in the same way in all 27 member states. Otherwise, to take the example again of Gabrielle de Frenne, you might have had some member states saying, in my national legal system, the rule of EU law cannot be directly invoked. And other legal systems would say it can be directly invoked as a matter of national law. Whereas this is not a matter of national law, this is a matter of EU law itself, namely that EU law, being a law common to 27 member states, needs to be invocable, needs to be capable of being relied on in exactly the same way in all the 27 member states. Because without that, the equality of the citizens of the member states before EU law would be breached. Uniform application is the ultimate guarantee of the rule of law, the rule of EU law, namely that all citizens are equal before EU law. So, the Court of Justice of the EU is indeed the institution that ensures that the law is observed in the EU law, in the EU. That is, in fact, that EU law is observed. And the court takes on that responsibility along with national judges. EU rules must therefore be uniformly interpreted, applied and enforced. The EU forms a single legal order, one legal order, a common legal order, in which the equality of member states and equality of EU citizens is to be protected.